Hello, everyone, and thank you for joining us for our program overview of setting agreements and land use considerations for solar and energy storage projects in Virginia. My name is Brad Nowak. I'm partner and co-chair of the Renewable Energy Practice Group at Mullen. Our renewable energy team has over 30 attorneys in 7 offices in Virginia, North Carolina, and South Carolina who work on practically all aspects of solar, energy storage, and other renewable energy development and other matters. I'm very pleased to be joined this morning by my partner, Steve Romine. Steve is a real estate and zoning attorney and member of our firm's solar and energy storage team. Steve has represented developers on land use matter for solar projects in Virginia and North Carolina, and has experience drafting and negotiating siting agreements. Steve is a member of our land use team, which has 9 attorneys and who have been involved in solar and other development matters in over 90 localities throughout the Commonwealth. Before we kick off today's program, I have just a few housekeeping items to go over. At any point during today's presentation, you may submit questions by using the Q&A button at the bottom of your screen. We'll answer your questions, time permitting, at the end of our presentation. If you have any audio or technical problems, please use that same Q&A button, and we'll also respond to those via that screen there. And then finally, at the end of the presentation, we will send around the copy of today's PowerPoint presentation. Now, today's program is the last webinar of our 5-part solar and energy storage webinar series. Over the course of several months, we've held 4 other webinars. If you've missed any of those other webinars, they're available on our resources page on our website. We've got a lot to get to today, so let me pass off the program to Steve, who will kick us off with an overview of the program and begin with this presentation.
Thanks, Brad. Good morning. I'm delighted to be with you today to talk about, on the overview slide here, we're going to be talking about the siting agreement statute, some of the background, notice requirements, substantial accord, and considerations when seeking local zoning approvals. Next slide, please. Virginia was very progressive when they adopted the Virginia Clean Economy Act in 2020. Progressive in the sense they were on the kind of the leading edge of states nationwide. The legislation set goals, but it didn't instruct how to reach those goals. Within the renewable stack, solar facilities provide diverse approaches, and there are more options with solar than there would be with wind and other renewables. For example, solar projects are diverse because they're geographically diverse in different states and different counties. They're diverse in size by the amount of acreage needed and the megawatts to achieve it. Solar projects are diverse in their investment structure, and they're diverse in their ownership and operation. The Virginia Clean Economy Act authorized siting agreements as a tool to provide economic benefit to the localities. It required Dominion Energy and Appalachian Power to be carbon-free by 2045 and 2050, respectively, and it provided statewide mandates, but local approval. I'm going to digress just a moment here to give some fill-in on land use, particularly with solar projects. So a solar project may typically comprise of 3 tracks. The developer owner needs to obtain its PJM position or its utility position, and also assess its infrastructure upgrades. That's one track. The second track is a land use approvals track, and the last track would be the EPC phase or construction. Today, we're just going to be focused on the land use issues on that approval track. So a solar project is basically a typical land use project, not unlike other large projects like telecommunication infrastructure build-out, data centers, and the like. Each project is unique because the land is unique, the locality is unique, and the developer needs are unique. Each project has a life of its own. However, there are fundamental principles that apply, and I listed 5. First, you must start with the end in mind. In other words, your local approvals require an affirmative decision by the legislative body, usually the Board of Supervisors. We have to appreciate the composition of the board, whose district the project sits in, and the history in that locality with respect to solar projects. First impressions are important, and you must be able to cobble together a majority on that board to obtain an approval. Secondly, you need to appreciate and understand the importance of the staff recommendation. Understand their resources. Many places are under-resourced because they don't have budgets. They can go outside the third-party consultants, and they may have varying levels of sophistication. Thirdly, you need to understand the role of the Planning Commission, who's charged with evaluating the land use aspects. Many planning commissions like to go further and get into the political side of things. You try to keep them reined in, and that they're supposed to really evaluate it for land use provisions. Their recommendation is usually only a recommendation to the board, except with respect to substantial accord when it's applicable, and I'll talk about that more in a minute. Fourth big point is community engagement is critical. It must start early. You need to frame the issues and dispel misinformation. And lastly, we need to manage the professionals and the engagement. There needs to be precise communication and thorough preparation. Next slide, please. Okay, so let's take a quick look at the enabling statute that was enacted in Virginia. So the Virginia Clean Economic Act was adopted on April 7, 2020. In its original enactment, the statute applied to projects in opportunity zones, and it was expressly trying to target disadvantaged areas. There was no battery storage mentioned in the original act. They amended the act on March 11, 2021, virtually a year later, and now we're a year later now, so it's only been 1 year since the amendments to the act. And what they did there was they eliminated the requirement you be in an opportunity zone, and they added in some battery storage language with a few other amendments. So let's take a look at the language on your screen. So this is the part of the statute that really relates to siting agreements. And so what this says is that if you're going to do a project in a locality, you have to give them written notice of your intent to locate, and you have to request a meeting, and then you would go into a negotiation. So pretty broad language, but a requirement that you've got to give notice. And the second part talks about what the siting agreement may include. 2316.8 talks about the power of the host localities, and 2316.9 is the effect of the executed agreement. We'll talk about that briefly in a minute. Now, if you look at the language here, let's look at A first. Next slide. So 7A requires an applicant to give notice. The notice contents, I don't think are that material, other than you just tell them, hey, we're going to locate a project and deliver that letter. I would suggest that you deliver it somewhat contemporaneously with the filing of your application. And that way, there's no question debate that you gave proper notice. Some localities require pre-meetings with adjacents before filing. I know Augusta County has that requirement. And so there may be some upfront work you have to do with the community before you even file an application. I'll discuss the timing and the engagement a little later in this presentation. Go back one slide, please. I want to focus on the language in B, okay? In B, you see the siting agreement may include. So as a lawyer, you always look at mays and shalls to see if it's prescribed or not. So most people look at this and say, well, this is what has to be in there. We have to kind of draw the lines and the dots. The siting agreements I've done, I haven't seen people go much outside this laundry list, but I don't think it's an exhaustive list. I think there's other things that can be included in the siting agreements. In some localities, the siting agreements end up being the kitchen sink, and they incorporated a lot of the conditions from the use permit in there as well. Next slide, and then the next slide. Thank you. Let's talk briefly about comprehensive plans. And this really relates back to substantial accord and some of the process you have to go through. Comprehensive plan is required. The local planning commission has to prepare and recommend, and what it does is plans for the physical development of the land in the jurisdiction. And it's supposed to be updated every 5 years. which is not necessarily done. I'm only aware of maybe one jurisdiction in Virginia that doesn't have a comp plan. There may be others. So even though it's mandated by law, not everybody has it. And a lot of people don't amend it every 5 years because it's a little bit involved. And that process requires you go out to the community and get input. So when we started out with a solar, 2-3 years ago, most comprehensive plans never anticipated solar. So they are typically absent provisions addressing solar. So one of the initial obstacles a developer will face is, does a comp plan address solar? And then the question is, if it doesn't, does it make sense to amend the comp plan to accommodate your project? So if you're trying to build in a certain district and it's not allowed, and you want to get it allowed by use permit, otherwise you might have to amend the comp plan. Now that's a little more involved, and that's really more of a strategy you got to take a look at. The second thing is, can you find support for your solar project in the existing comp plan? And I've always said, your comp plan can have a lot of broad language in it. And there's usually provisions in the comp plan talks about economic development and jobs. And there may be other provisions that talk about preserving agricultural land. So within the same comp plan, you may have some conflict or some debate. And so as representing the developer, we always go through there and try to find supportive language. We make our case, yeah, it's consistent with the comp plan because, it's good for economic development and we're creating jobs and stuff like that. So many times it's not always a stretch, but sometimes it's hard to find support in a comp plan that wasn't otherwise written to address solar. Next slide. So we said most comp plans don't have much on solar. So why is that important? Well, because the localities are required to make a substantial accord determination. And this substantial accord can be a little bit of a hurdle. In section 2232A requires that to determine that that particular project's in accord with a comp plan. Substantial accord is usually the first approval required and can be a hurdle. A negative finding can stall the project, but it is appealable to the Board of Supervisors. So when you look at substantial accord, that's where you make your argument in the comp plan that, oh yeah, the comp plan supports this project because we're creating jobs and it's good for economic development. Then someone will come back through and say, well, no, it's not compliant with the comp plan because we say right in here we want to preserve our agricultural land and our rural aesthetic, and then you get that debate back and forth. 2316.9C on the screen here. So approval of a siting agreement by the local governing body shall deem the project to be in substantial accord. So that's one of the benefits of entering into the siting agreement. You get a substantial accord approval. Now the devil's in the detail, because the question is, when do you know you can have a siting agreement? And when does that locality want to put you through the substantial accord? And let's say you go in and you get a negative finding on the substantial accord, you then appeal it to the board and say, board, overturn this, and contemporaneously you may be negotiating that siting agreement. So if you achieve the siting agreement, then trumps the need for the substantial accord. So there is a timing and a negotiation strategy you got to look at as you go through this process. Next slide, please. Okay, let's talk about ordinances. So we talked about comp plans, we talked about substantial accord. So really, the most important thing a locality can have is an ordinance. So solar ordinances are critical. Unlike the comp plan, they are statute. They are the law. If you don't fit within that ordinance, then you're out of luck, or you have to ask for a text amendment, or you have to find a way to navigate through that ordinance. Some localities have not adopted an ordinance. And in the early days, when you looked at the zoning code, we were trying to find categories where you could drop a solar project in. And most of the time it was under some utility provision or section that wasn't perfect and could have been actually challengeable. So as a zoning attorney, I'm always trying to make my approval bulletproof. Obviously, it can be appealed, but you don't want to spend $100, $200 million. And then 2 years later, someone brings a challenge that something wasn't done procedurally correct. or you have a flaw. I mean, that is just a nightmare. So you got to make sure that you are navigating the process properly. Many ordinances are poorly drafted. There's inconsistencies and ambiguities. For instance, the ordinance may describe the project. And I saw one ordinance where the project description was used with a defined term in two different terms. And then there was a third section where the narrative was talking about a project and describing it. And none of the three were consistent. So we couldn't tell, because this particular locality had a 1,000-acre cap, we couldn't tell if it included buffers or not, or screening or not, or whether it was just under panel. So some of those things become problematic and subject to interpretation. So sometimes you got to go into the zoning administrator, the planning director right up front and get a discussion, and that can be delicate. You want to be careful how you have that conversation, because you don't want to raise a problem that isn't otherwise there, but you also want to protect yourself on the backside if something isn't right. Even fewer localities have adopted battery storage ordinances. I'm going to mention Prince George County sort of as a little bit of a case study, and I think it's okay. They adopted the solar ordinance in April 2017. So they were pretty early on. That was 5 years ago. And in that original solar ordinance, they basically went through and they designated the districts where you could do solar projects, and they were with a special exception by and large. And they had one district, the M3, that was by right. So they went through very carefully and they just dropped in utility scale solar projects. And then in August 11 of 20, about 3 years later, they adopted a very comprehensive solar siting policy. And the policy about 14 pages long, there's a lot of detail, and it reads sort of like a comp plan. And so what I'm finding is, and I'll get to it in the next slide in a minute on policies. Yeah, let's go to the next slide. That'd be fine. Yeah, on policies. So the question is, what is a policy? Okay, we know the policy is not an ordinance. So right on the bat, we say, well, okay, that's a guidance document. It's not a mandatory thing we have to follow. But then the question is that policy sort of an extension of the comp plan? And is it baked into the comp plan? Well, I would argue you got to amend your comp plan to drop that into your comp plan. But what some localities have done, adopted a policy, and then they wait for their 5-year rotation, and they pick up all those amendments in the comp plan. So I think for planning purposes, it probably makes sense to treat the policy as an extension of the comp plan. I can tell you the policies, there's a lot of detail in those policies. That's where you see the caps on acreage, the distance between your project and another project, just between your project and a town boundary. A lot of those restrictions are being dropped into policy. So on the slide here, you'll see, in addition to the comp plan, they might adopt these policies. They impose caps. There may be some enforceability issues, but you do have to consider it. So if I go into a county and they've got a policy that, let's say, caps the size, or they say you can't use prime soil, farmland, the question is, how do I deal with that? How you deal with that? That's an expression of the local, particularly if they adopted it at the Board of Supervisors. Some policies don't go through the formal adoption, but if it's been formally adopted, it's an expression of the locality's guidance to the outside world that this is how we're going to monitor and evaluate your project. So be aware and treat it accordingly. So that can be a consideration. And then after August 20, Prince George then adopted a separate battery storage ordinance. So that's sort of an example of some progression in a typical county. That one's good because they adopted an ordinance early. In their case, they amended 3 years later with a policy, and then they subsequently came behind to adopt a battery storage ordinance. Let's go to the next slide, please. Okay, in the last few minutes, let's talk a little bit about negotiating siting agreements. Sometimes there are acreage caps and other limits. And the question, I'm going back to these policies, they're probably enforceable. Let me just leave that. So let's look at slide 12. So the most important thing, yeah, one slide forward. Yeah, right there. That's good. The most important thing in this negotiation process is probably determining early on and upfront who the decision maker is, who has the authority to negotiate, who can ultimately sign the agreement, who can deliver the bacon, and so you kind of have to identify that. That's not always intuitive. It's not always obvious. I've worked in many jurisdictions, and in some it's the county administrator together with the board chair. Others it's the planning director with the county attorney. So it can vary. But you got to determine pretty early on, if I'm going to do a siting agreement and I want to achieve the benefits, I've got to engage the decision maker. The next question is, when do you engage? Well, when you give your notice at the time you file your use permit, there is probably an argument and debate as to when you want to do this. Some of the transactions I've done have run fairly orderly, and there's been support for the project. So we've worked through the zoning pieces first, and then started to run our negotiations with the board after the planning commission had sort of engaged on the permit, and then ran that on a parallel path in executive session to try to reach an agreement. Because the first thing I was told when we started doing siting agreements was the board doesn't want the optic that they're signing off on a siting agreement that trumps the zoning, so that the zoning process gets cut because it hasn't been vetted all the way through the community input, the planning commission, and up to the board. So it's very critical for a board, in order to avoid criticism, that the siting agreement is done. It can be done on a contemporaneous path, but likely that it not be approved ahead of taking a vote on the use permit. Now, I would recommend typically that you would plan it so that when your application goes to the board, that if you get your approval, that same night, right after it, the next action would be the public hearing, because you have to have a public hearing on the siting agreement and an approval of the siting agreement. So you lock that down, and there's no chance that something could slip. The other issue is the locality may drive the timing of your siting agreement. I've dealt with certain localities that the economic benefits are the most critical part of the project. So they want to know the economic benefits up front before they really make a lot of decisions on the land use side and whether they're going to support it going forward. And so you may have to engage in your conversation on the economics and what you're willing to do and how that siting agreement is going to look earlier than you would prefer. So I've seen it both ways. I think each project, like I said at the beginning, are unique. You kind of have to look at it. Now, the one thing I will express, which I don't know is always fully appreciated, is the confidentiality. It's critically important that these economic conversations be kept confidential. And that's why I prefer that they occur in executive session at the board meeting. So you could sit down with the county administrator, if it's a strong administrator, have your conversations and say, hey, this is what we're thinking about. You can even go back and forth on some of the numbers and the needs, because they can identify what they want addressed. And then you can get in a board session, and the county administrator can actually go to the board and share that in private session without the developer. But at some point, you might want to ask that you be in the meeting so that you have a conversation back and forth. And then you kind of have a handshake or an idea that, yeah, we've got the framework for an agreement that's going to be acceptable. The reason you leave it confidential is many times your planning commissions want to get into, well, what's the siting agreement say? Are you entering in a siting agreement? What are we getting paid? And that's really completely outside their purview. And it just will make your transaction complicated, and it's really not appropriate. So I'm pretty adamant about that, because I think you can get sideways if that information gets out, the cart ahead of the horse. Let me see my notes. I think I've touched on everything I wanted to do. And I think we're right at maybe 4 minutes left, Brad, so I'll kick it back to you.
Sure. Thanks, Steve. And that was a good segue because I think our first question is about siting agreements. It's a multi-part question. I think some of which you've answered, but I'll throw it out there. It said, who's typically involved from a locality when negotiating a siting agreement? How long does that process typically take? And is there a public meeting where the siting agreement is discussed?
Okay, I think I probably hit most of those, but I can go back just for a minute. So it's, again, identifying the decision maker, and there's no right or wrong, but I do worry, and this is not a criticism, but each locality has a personality of its own. You may have a county administrator that's been there 3 months, doesn't have established rapport with the board, still on the honeymoon, and doesn't really have the authority to engage that. And maybe the planning director's been there 25 years and he's the one that's doing that. Or maybe the county attorney has negotiated 5 of these already and he's taken the lead. But ultimately you got to find the person or persons that are going to be able to deliver the negotiation. And then I typically think you have to have the board involved somehow. And the ones I've dealt with where you have a strong county administrator and a great relationship with the board, they're in dialogue. So they're in lockstep. And those are ideal when he can take it or she can take it to a board meeting, an executive session, and come back and give you feedback, sort of shuttle diplomacy. That's ideal, but that can be problematic. On the timing, again, I historically, if it's a project that feels like there's support, the use permits moving ahead, doesn't feel like there's a lot of opposition, then I'd like to go ahead and file the application, give notice of the siting agreement, and then say, hey, we're happy to engage whenever you want to, but maybe preferably, maybe after we get through planning commission, or send us a template of an agreement you guys may have already entered into. If you don't have one, we have one that we like, and you can send that back and forth. And then the big question is, when do you start plugging in the numbers? When do you start plugging and identify the projects or the needs you want to support? How long it takes? Typically, you're going to want to get it done before that use permit hits the board's calendar for a public hearing, because I don't want that siting agreement trailing a month or 2 or 3. I want that to be bang, bang. I want my use permit approved, and with that momentum right behind it, approve my siting agreement, and we've got a done deal. And then the 30-day appeal time frame runs.
Okay, and next question we got was about decommissioning. Is a decommissioning agreement negotiated at the same time as the siting agreement?
That's an interesting question, because what I've typically seen is the decommissioning is built into the conditions of your use permit. And they're usually pretty detailed and a lot of stuff in there with bonding and how much you have to remove and all that stuff. I have seen siting agreements incorporate by exhibit all the conditions of the use permit. So in other words, they'll say, this is our siting agreement, you're going to pay X on X date, and this, we've agreed all this, and this is sort of a double band-aid, and you agree again to fulfill all the commitments and the use permit conditions and some of which may be the decommissioning, and they sometimes can regurgitate decommissioning provisions right back into that siting agreement. And that's a little overkill, but I think it's such an important point to them that it doesn't hurt. If it's belt and suspenders, I'm not worried. But typically, I think your decommissioning provisions and conditions built into the use permit are fully enforceable, and there's really no need to put decommissioning in the siting agreement.
Okay, it looks like we're out of time. I know we've got several other questions, so we will follow up afterward to answer those. But thank you, everybody, for attending today, and especially special thanks to Steve for presenting. If you've got any other questions, feel free to email us at our contact information or email us at solar@williamsmullen.com. And once again, thank you for attending our webinar series, and we'll look to see you at our next one.
Thank you, Brad.